I'd very much like to thank the committee for inviting me along to speak today about my research, and to all of you who have actually come along to listen. I feel very privileged to have the opportunity to present the first of the Elvin Fist lectures. And I did my teaching degree at the Newnham campus of the University of Tasmania. And the School of Education at UTAS clearly owes a great debt to its predecessor institutions and to the leadership of Mr. Fist. Now, Samuel Goldwyn, the famous movie producer of Metro-Goldwyn-Mayer, and that's the Roaring Lion one for those of us before the era of Netflix, he's reported to have said, "We want a story that starts out with an earthquake and works its way up to a climax." So we will start with in a moment, we'll start with a school law earthquake, but not literally. It's a story about two school principals. The first abandoned the school in abject disgrace. After a long career and a formerly brilliant professional reputation, it was in tatters. After becoming embroiled in a legal dispute of epic proportions. The second of our school leaders is a young principal who was quickly promoted to fill the vacancy. On day one, the bright, shiny replacement opens a filing cabinet and discovers 3 envelopes marked 1, 2, and 3, left behind by his predecessor, along with instructions to open them in case of emergency. A month later, the new principal discovers that the doors in the school are too narrow for a student's motorised wheelchair. Not knowing what to do about disability discrimination, he opens envelope number 1 and reads, "Consult the legal manual." He does so and finds an answer. 3 months later, he discovers the woodwork teacher in the stationery cupboard with a struggling and protesting music tutor. Not knowing what to do about sexual assault, he opens envelope number 2 to read, "Call legal services." He does so, and the situation's resolved. After 12 months in his new appointment, the principal looks out of his office window to see the elderly art teacher posing for a life drawing class, being observed by a group of primary school students come on an orientation visit. 5 parents just arrived for tuck shop duty, and a journalist from the local paper. not knowing what to do and desperately in need of guidance, he opens the third envelope and reads, "Get yourself 3 envelopes." So now that the earthquake is out of the way, maybe you should do the clicking. How did you do it? Yeah? Done. Just click. Okay, sorry. I'd like to tell you a little bit about myself and what brought me to investigate the very niche topic of school law. As Dr. Ratcliffe has said, I'm a born and bred Lonnie girl. In the late 1970s, I couldn't type, I didn't want to be a nurse or a teacher, so I went to Hobart to study law instead. I had an interesting patchwork career as a legal officer in the regular army, court-martialling wayward soldiers, and then as a legislative drafter, writing laws for Parliament. Then motherhood, which was so much harder than the army ever was. When my son went to school, I became a tuck shop sandwich maker and helped out in the classroom. And I realised that my parents had been right all along and I should have been a teacher. So I did a teaching degree, again at UTAS, and I stayed on to do my PhD. So I ended up combining law and education in school law. But there were 2 memorable incidents that stirred up my academic passion. One momentous day at school pick-up time, I found a child in the playground, tears, hiccuping sobs, runny nose, slightly grazed knees, but no blood. So I picked him up and dried his tears and gave him a hug. And I turned round to find the principal behind me, who said, "It's illegal for an adult to touch a child." Now, she was really scary, so I didn't say anything, but she was wrong. Then, when I was doing my teacher training, we did a subject on professional conduct, and the same fictionalised version of the law came to the front. We were told, the law says you can never, in any circumstances, offer a child a lift home in your car. That time I did stand up and point out that that may well be unwise. It's probably precluded by education policy, but it's not the law. To no avail. And so, as a lawyer, teacher, mother, student, I ended up researching the law relating to schools and the legal knowledge of school leaders. During the presentation, I'll talk briefly about the research basis for my PhD and school law research in Australia. And I'll go on to discuss the findings. At the end, we'll come to a climatic conclusion. Perhaps because of the degree to which education has been legalised in the United States, there are a very large number of American studies about the legal knowledge of school principals, and they overwhelmingly find that it's inadequate. By comparison, the Australian research landscape in relation to school principals and school law is, to say the least, limited. But we've also found that school principals' legal knowledge could be improved. There were 2 Australian studies preceding mine, both based in Queensland, who looked into the impact of school law on government and Catholic school principals in 1996 and 2006. My work was reported in 2017, and there's been one subsequent doctoral study in 2021. So not a lot. This is despite the fact that the importance of legal issues in the work of school principals has never been higher. School leaders now face an ever-expanding range of legal issues. Areas of law are becoming more complex, and there's a widely held perception that students' parents increasingly turn to the law to settle disputes. My PhD was based on research carried out here in Tasmania from 2013 onwards to investigate the impact of legal issues on school principals across the government, Catholic and independent sectors. It focused on legal literacy and legal consciousness, which we'll talk about a little later, the legal context that they face, the negative impacts of their legal dealings, and ways in which their situation might be improved. As an aside, let me tell you a little bit about how my PhD journey played out. Like many doctoral candidates, it was not a smooth path. Firstly, the scope. When I first approached my supervisors with a research proposal, there were visions of a grade A, fur-lined, ocean-going, Australia-wide study of the impact of school law on school principals. After 6 months of data collection, nothing. In academic barbecue terms, not a sausage. A total of 3 responses to a nationwide survey. So I felt like giving up. So we pared down the scope of the project to focus on Tasmanian school principals. And with my Tasmanian background, I thought, I'll have gone to school with most of them, or at least my auntie would have worked with their sister-in-law's cousin at Peyton's and Baldwin's mill at some stage. So that might work. And it did to an extent. An online survey to 261 Tasmanian principals went out and I got 34 responses. Not good, but better than 3. I still felt like giving up. So thirdly, the plan changed to include some interviews to pad out the blanks in the survey results. But the survey data really didn't say anything new, and the interviews were really interesting. So we changed the research design again. It became a mixed method study based on a small quantitative input, and that was from the survey results, but a much bigger qualitative emphasis reflecting the interview data. So I didn't give up, and here we are. In summary, the quantitative data were collected first through an online survey of Tasmanian school principals. The survey covered participants' legal training, the areas of law they dealt with, the information sources they relied on, the time they spent dealing with legal matters, and legal stress. It also included a few questions about Tasmanian anti-discrimination law, which one would think school principals would be expected to be familiar with. Following on from the survey, I conducted 26 interviews with participants who included government, Catholic and independent school principals, and also with supervisory principals, education system leaders, educational administrators and an education lawyer. The study was the first in Australia to begin to address the experiences of independent school principals, as well as their colleagues in the other systems. It also provided a more complete and rounded picture of the situation by not just talking to practicing principals, but including perspectives of other informed education professionals. Now, in research speak, this process is called triangulation, examining an experience from more than one perspective to gain a deeper understanding. It's a little like military map reading triangulation, where you find out where you are by taking readings of different points and seeing where they intersect. But there's nothing more dangerous in the army than a legal officer with a compass. So we'll move on. The findings. What did I find? The first research area I examined was the legal literacy of Tasmanian school principals, and that's very much an umbrella concept, covering the legal areas they deal with, the sources of their legal information, and the accuracy of their legal knowledge. The survey participants reported dealing with a wide spectrum of legal matters. One would hope that an individual principal would not face such an array of headaches in a single week or even over an entire career. But within that range of areas were core issues that they were most worried about, relating to, as you'd think, the safety, welfare and legal rights of their students, the parents and the staff. These core issues were education, the duty of care, which is covered by negligence, child welfare, employment, family law and discrimination. Now, some of these legal issues have serious consequences for the parties involved, as well as being potentially damaging to the effective management of the school In such circumstances, a school principal may need access to a legal advisor who can provide some decision support. What sources of advice do principals consult when a legal problem arises? Firstly, across the board in all sorts of schools, for common or garden variety issues, principals rely on their own knowledge and experience. They consult a handbook or they phone a colleague, and we'll come back to that. The differences between government, Catholic and independent school principals are really highlighted when you start to talk with them about the non-routine matters, the ones where you throw your hands up in the air and start planning your long service leave type situations. For principals within the government and Catholic systems, they can seek advice up from their supervisors. And above that, the public school system has in-house lawyers to provide advice. The Catholic school system uses a large private law firm to provide advice. Now, the participants of well-resourced independent schools reported that they maintain a relationship with private law firms to provide them direct advice as required. But it was concerning that principals of some small, less well-resourced independent schools reported seeking legal advice only when they're absolutely forced to do so on the steps of the courthouse. Indeed, the principal of one faith-based small school explained to me that when a legal issue arises in her school, they don't consult a lawyer, they pray. And she assured me that so far it's worked. It's generally accepted that school principals need some legal knowledge to fulfil their responsibilities, and that's recognised by the Australian Standard of Professional Practice, which applies to all school principals. But what do they get in terms of university training? To my shame, it's possible that a Tasmanian school leader may have had as little as 3 hours of training about school law during their teacher training. And that could be it. A small number of my survey participants, and these all came from the Catholic and independent sectors, had done a university course specifically about school law. Now, this probably reflects the professional requirements of those systems, but there may also be an influence of the University of Tasmania not offering any postgraduate qualifications in school law here in Tasmania. There are courses in other universities. But most of the principals I spoke to did do some legal in-service training in the previous year, which was really encouraging. But many of the more experienced principals reported that they had chosen not to attend any legal workshops or conferences or information sessions on the basis that they had already done it all and knew it all, which I think Sir Humphrey from Yes Minister might describe as a courageous decision on their part. Which brings us to the legal knowledge test. If we were in the United States, this is pretty much the only result that anyone would be interested in. Based on the legal knowledge questions in my survey, the principals who responded showed a limited knowledge of discrimination law. On average, 52% of the questions were answered correctly. This falls short of the generally accepted standard of 70%. The more experienced principals from larger metropolitan government schools scored higher than the rest of the principals. Catholic and government school principals scored higher than did independent principals. Almost 60% of the principals I surveyed were extremely confident about their own standard of legal knowledge. But this wasn't then reflected in their legal test results. And I refer you back to the principals who rely on their own experience and knowledge in dealing with legal issues, as well as those who phone a friend. And they may have a similar or even greater level of misunderstanding of the legal rights and obligations involved. Now, so far I've talked about the results from the survey data and honestly mostly confirm what had been found previously in Australia and overseas, particularly in the United States and Canada. But now the emphasis switches to the more interesting interview results. Now, the accepted approach to researching school principals and school law is to give them the legal knowledge test. And I did that and I got the same poor results. But speaking to principals, it emerged that there really might be a difference between their legal knowledge of the content of the law and their beliefs about the way the law works. And this traditional legal knowledge test doesn't capture these beliefs. I thought this was really interesting, and so I pursued this idea of legal consciousness, which comes from the slightly touchy-feely, hippie area of legal sociology. And it's not something that's been previously discussed in terms of school law, but it has been taken up since and been extended by other researchers. Legal consciousness is about the meanings given to law by everyday people who aren't legally trained in their working and their personal lives. When some of the participants in the study were asked what school law meant to them, they gave the predictable textbook answer about following the rules and the legislation. Principal Quinn said it's the legislation that dictates to us how our schools should be run, which is absolutely true. But other interview data suggested that school principals may understand the law in ways that fall outside this idea of the rules and the statutes, underlining the importance of their subjective, personal beliefs. The interview data revealed aspects of principals' legal consciousness, including the idea that school law meant school safety, that it was really about school leadership or personal ethics, or that it was just common sense. The identification of school law with students and sometimes school safety was expressed by several people. One participant raised the idea about restraining a violent student, commenting, "A situation where a violent child needs to be restrained for the safety of other children. You've got to make the judgment call. And I guess if it's based on safety, that's fair enough." Several participants connected the operation of school law with the practice of school leadership, and this was most clearly expressed by Principal Ainsley, who stated, "You have to ask questions about the leadership and the makeup of the school's governance and management structure if it's being sued continually. It could be that the clientele in that school is dissatisfied. But even that, with good leadership, you'll find a drop-off in complaints." Other interviewees talked about a connection between law and ethics, suggesting that ethically sound conduct in some way satisfied the requirements of the law. According to Principal Drew, "I think if you're acting ethically and keeping the priorities in the front of your mind the whole time, the protection and welfare of the students, and you're acting ethically, then whatever transpires down the track, legally, your behaviour will have provided you with that protection. If you act unethically, then you could be headed for problems." The final aspect of legal consciousness that emerged was the primacy of common sense over law. Principal Ainsley talked about an incident of a student who climbed up a tree in the school grounds. One teacher wanted to jump in the tree behind her, and I said, "No, you have your own safety to check first. Common sense." And she said, "But what if the child falls out and I'm responsible?" I said, "No, your own safety comes first. That wasn't the law, that was common sense." In fact, Tasmanian health and safety law does require that a worker has to take reasonable care of their own safety. But the principal seems to have believed that somehow the demands of common sense might have overridden the legal obligation. In summary, the interview data suggested that some school principals thought that the law wouldn't apply to certain acts if they were carried out for what the principal saw as a higher motivation. If they were done in the interest of safety, if they were ethical, if they made good sense, or even if they were good for the school. Now, the principal's knowledge of the law may or may not be accurate, and their beliefs about the law may or may not be legally accurate. And I'm not drawing any conclusions as to whether they were. But legally accurate or not, these beliefs about the law seem to have influenced the principal's decisions. And so it's my argument that this concept of legal consciousness, evidenced by words, might provide a piece of the puzzle that's missing from the purely numbers approach of the legal knowledge test. But that's really a topic to go into in a future PhD. We go on to the legal environment. We do. Now, the issue of the legal environment in which principals deal with legal issues does not sound particularly interesting even to me. But I think it's important to recognise that there are pressures within the working environment that affect the legal decisions that principals make. One previous Australian study looked at the pressure on principals to minimise the legal risk in their schools. Another focused on the influence of the faith systems in Catholic schools. I looked at the influences of critical individuals and organisations within and outside the school, the students, the families and staff, different tiers of national and international governance, and the education systems themselves. So in doing so, I really just widened the conversation about the principal's legal environment. And that's the formal academic perspective. I think this view is a little more engaging. Another theme that emerged from my research was the negative impacts of dealing with legal issues on school principals. Now, there are impacts on the school themselves. These could include damage to reputation, the cost of actually obtaining legal advice, the financial costs of settling legal matters. For students, their learning activities can become narrowed and sterilised from misjudging legal risk decisions, or perhaps from unfounded fears about getting sued. Now, all those decisions were not necessarily based on misunderstanding, but they are things that have happened as a result of the perception of legal risk. So that's consequences for the school and for students. For the principals themselves, there are costs in dealing with legal matters. The time that is taken up in dealing with routine legal matters every week. Principals saw these legal matters as complex, lengthy, distracting. Taking them away, oh dear,
Sorry, did I do that?
I don't know, did I do that? Taking them away from the bread and butter of leading the schools. 40% of the principals I spoke with reported suffering from legal stress. and they described their experiences using words like worry, inadequate, overwhelmed, and underprepared. What I found out from the principals themselves about how to improve their legal lot was pretty much as you might expect. Most thought that principals' legal training should be increased in preparation for the principalship. They also thought there should be more legal training for teachers and for pre-service teachers, which is what they now call student teachers. And perhaps such training might result in fewer legal problems arising. And the training should concentrate on core legal topics: safety, welfare, and legal rights. In conclusion, I've done it again. In conclusion, many of the findings of my study were similar to the conclusions reached by previous Australian researchers in 1996 and 2006, which is a little bit worrying. Although I looked at the experiences of a broader range of participants in a different Australian jurisdiction, years later, many of the results were the same. It was déjà vu all over again. And while this was not part of my thesis, I think it's fair to ask, why had things not appreciably changed over the 2 decades? Is it because of the gaps in preparing the teachers for the principalship? Are principals themselves resistant to taking on new knowledge? Or are the education systems themselves generally satisfied that mostly it's okay? Or is our research missing something important? And these are issues which need further investigation. There were some new ideas that emerged from my study and added to the fund of knowledge. The different legal support frameworks around principals, routine and non-routine decision making, especially the legal resources which are available to independent principals. And how does legal consciousness of principals influence their decisions and the accuracy of such beliefs? And how do the different environmental influences play out in the real-life decisions made by school principals? I can safely say, from my reading and research, that the role of the modern school principal is legally challenging and can be fraught with pitfalls. I got to the end of my research and thought, I wouldn't be a school principal nowadays for quids. School principals don't need to have law degrees, although some do. But they do need training in the everyday legal issues they face. They need access to legal support to prevent minor issues escalating into major dramas. And importantly, they need a sound appreciation of when to seek help. And this may be just such an occasion. Which brings me to the end of my presentation. Thank you all for listening so intently.
Some questions and comments.
Absolutely.
Just while you're formulating your questions, it seemed that in one of your opening anecdotes, the problem is a lack of understanding of the difference between law and regulation and policy. Policy is a sort of a fog that covers the lot.
It does, yes.
Regulation, which is detailed but sometimes treated as if it was law, and then law.
Yes. Yes, from talking to principals, there was a misunderstanding of the different levels of obligations and responsibilities. Of course, if you work within an education system, you're required to operate within the policies of that education system. But above that, there are legal obligations and responsibilities that are primary, you can't get away from. But there is, to a great degree, misunderstanding between its policy and what the law says. Yes.
I have a couple of questions. One's concerning your research methodology. You stated that you had a bunch of principles that you did a quantitative survey on, and then you had a bunch of principals and a bunch of other guys that you did qualitative interviews with.
Yes.
So 2 questions concerning that. One is, what was the intersection of the survey principles and the interview principles? Did you deliberately seek out some survey principles? A usual technique here is to get interesting things arising in your survey, which you flesh out more in your interviews. So you try to have the same participants to some extent. So what was the basis for selection of your interview candidates? That's the first question, if you can hold that in your mind. The second one concerns those other guys that you interviewed, the non-principals. Your claim for including them was that you might get different perspectives from these guys to the ones that you got from the set of principals. Not much emerged in your talk of what differences did come out of the woodwork in those interviews. Were there different understandings, different legal consciousnesses, given that's a concept that you were wanting to play with? So were there any differences that you could notice in your interview? Mind you, looking for differences with such a small sample is a bit of a statistical nonsense, but anyway.
I accept wholeheartedly that it was a very small sample. The first question about the intersection between the survey population and the interview population, the survey was entirely anonymous, and so it wasn't possible to chase up the particular respondents. The way that we facilitated the involvement of the interview respondents was through a snowball technique. I was supported by my supervisor, Dr. Neil Cranston, who had a great many contacts within the Tasmanian education system. And from the first interviews, the interviewees were most gracious and generous in suggesting other professional educators who may be interested. And I contacted them, and the sample grew from there. And if you could just repeat the second question very briefly.
Your interviewees were non-principals.
Yes.
So did anything different emerge from them to what emerged from the members of the principal set?
No, it didn't. All of the people who were not practicing principals had been principals in the past, and their data reflected both their experience as principals and also in their present positions. I can say that the system leaders and educational administrators were a lot more confident about the effectiveness of the current legal support framework than were some of the principals themselves. Yes.
Thanks very much for a very interesting presentation. You touched on a point at the end, which I was going to ask you. You indicated that because the law is changing and rapidly changing, that means perhaps it's getting more complicated being a principal. And you compared your results with people that had done the work 10, 20 years ago, but of course the law is changing and becoming more complex. How can you factor that in? And as we move forward, is it going to get even worse?
I think the short answer is I believe it will. And each research study has to be evaluated in terms of the circumstances when the data was collected. I think the participants, and this is just I think, the participants in Stewart's study in 1996 felt that they were overwhelmed by the law as it stood then. Then in McCann's work 10 years later, his principals felt that they were overwhelmed by the law as it stood then. And certainly the principals that I spoke to, not so much the more mature, experienced principals, but the younger ones who had not had very much preparation before joining the principalship, they were overwhelmed by the complexity of the law as it stands now.
But I suppose what I was getting at is, wouldn't you expect it to have been gradually getting worse over that 20 years ago, 10 years ago to today? It's been worse each time, whereas what you're saying is it's the same each time, because the law's getting more complicated. The principals must be getting better advice or something in the meantime. How is it staying the same? How is it not getting worse?
It was probably the question that was included in the survey and the data that was collected. The questions were along the lines of, do you feel prepared for the legal issues you're dealing with? Does legal administration cause you stress? Does it cause you more stress than normal, everyday educational administration? So I think it was the questions that we asked.
Have you been talking to people at UTAS about the possibility of extending their education?
I'm sorry, could you repeat?
Have you been speaking to anyone at UTAS about the possibility of extending their education? That is, putting on a course specifically for educators on legal aspects?
I'm not currently working for UTAS, and so I'll make a comment as an outsider. The School of Education at UTAS no longer provides any qualifications in relation to educational administration and leadership. It did at the time that I was collecting data, but there were very few students following that course. There's nothing now. Tasmanian principals can undertake study through the Australian Catholic University and the University of Sydney, where they have specific school law diplomas and legal courses, but there's nothing here in Tassie. Yes, Peter.
If I can be permitted a second bite of the cherry, it flows directly on from those points. You were advocating at one point, and still are, that part of the solution is simply getting these guys better trained in the law, either by a postgraduate diploma or graduate certificate or something. Graduate certificates are very nice qualifications for this, incidentally, because they can be done in one bite pretty well. You also said earlier that in your literature survey you had a number of studies from other jurisdictions within Australia and elsewhere. I don't know how rich the information there was, but it'd be interesting to know if in places where there was that sort of training, some form or another, either at an undergraduate level or within the departmental system, in-service training level or a postgraduate qual from a university or whatever, whether those guys had different feelings about their competence to cope with things or not. In short, it might well be that training the guys is not the answer to making them feel any more comfortable about what they're doing. And it might be that some rival answer like immediate, instant, pick up a phone and the problem's solved, in-house support is a better way to spend your money than mandating extra principal training.
I have to agree with you. One thing that I would point out when I mentioned how in the United States there's such an emphasis in the research about what score you got on the legal knowledge test. In the States, each state jurisdiction licenses school principals. And part of the licensing process requires them to sit a legal knowledge test, not the same test that is used in the research studies. But even so, the state licensing in the United States emphasises school law. The research still comes back and says that in terms of the research studies, principals' knowledge of school law is limited. So I think you're absolutely right. Training by itself does not appear to be the sole answer. Getting people really great handbooks about what to do when A occurs would seem to be worthwhile, and independent schools who are outside the systemic structure don't tend to have such handbooks. Immediate access to legal advice, I believe, is critical, and it was with the small, less well-resourced independent schools that I see a particular gap. So I hope that...
If God's on the case, then they're all right.
Perhaps for one or two.
Your work has been on the application of the law. Is there any need for the review of the law itself?
As a former law reformer, I believe that the law should be continually examined and reviewed, but I haven't identified any particular areas where I think there's a problem. Having said that, I think speaking to many practitioners in the field, there is a great deal of misunderstanding and fear about negligence, what negligence means, and what can happen when someone makes a bad decision. And I think if there was more clarity in that area, it would make the job of school principals anyway a good deal easier.
It sounds from your description of the methodology that you probably managed to net the people who had the most legal consciousness, and you found that they, at best, with a good wind behind them, came up to about 60% if tested.
Yes.
What about the 70% of non-responders? What depth of ignorance must exist in that realm?
As a neophyte researcher, it only became very clear to me that the people who responded are the ones who care about this issue. They're involved with the issue. They want to have their voices heard. It's definitely the ones who think everything's fine and don't want to be involved in the conversation, that it worries me a little.
Well, thank you, Allison. That was delightfully presented.